Hello, Gene the OK Boomer here. Welcome to today's vlog. Today's subject is something very near and dear to my heart. It's about gun control, but gun control in a specific area, and that area is New York City, where I lived. I've mentioned this in the past. I lived in New York for just about 40 years, a little over 40 years, and I moved to Tennessee. And one of the things, well, there was so much to like about New York, and a lot of what I liked about New York is actually doesn't exist anymore. So, well, that's another story for another day. One of the things I didn't like about New York was how hard it is to get a gun, a handgun, let alone carry it with you, a concealed carry permit. Virtually impossible in New York. New York is one of the few cities, and it is just a city. New York State, you get outside of New York City, and the state of New York is like pretty much everywhere else. The main problem is New York City. Very, very restrictive requirements to, well, I'm going to share this article with you right now. It'll give you some idea of what it's like, and the reason I'm bringing it up today is because it's finally, I had been writing to organizations such as the National Rifle Association, the Second Amendment Foundation, said, why don't you bring a case to New York or to go to the Supreme Court? Just bring a case to, there are a lot of people. I would have been a plaintiff. I would have been happy to have been a plaintiff to get a concealed carry license, and nothing would ever happen. The New York, well, the National Rifle Association, they always disappointed me. I don't think they ever take court cases. Maybe they'll file an amicus brief, but that's about it. I don't even know if they have a legal division. The Second Amendment Foundation, that is what they do. That's their purpose, to make it easier to own a firearm, a handgun, and carry it on your person. And they turned me down. They said the Second Circuit Court, which is a circuit court for New York City and that part of the country, they already ruled on it and on that issue, and they ruled against a plaintiff in some earlier case, and that was it. Nothing could be done. But it looks like there is an organization, the New York State Rifle and Pistol Association. They're a gun group. I guess you could call them a local National Rifle Association. They've brought a suit. Now they're going up to the Supreme Court, and the Supreme Court is going to hear the case. That's what I want to share with you today. I'll throw in some details because I'm familiar with this, having lived in New York and having been frustrated with not being able to own just to have a rifle. I had a rifle and I had to get fingerprinted for that. I had to get photographed and fingerprinted just to own a rifle, which is ridiculous. But, well, let's get through the article, and then I'll just fill you in with my personal knowledge as we go along. So here's the headline. Locked and loaded, Supreme Court is ready for a showdown on the Second Amendment. And by the way, I linked to the whole article so you can read the whole article if you want to. And I recommend that you do. It's by Jonathan Turley, one of my favorite commentators. He's a law professor. Anyways, to the article. In the movie True Grit, Federal Marshal Rooster Cogburn is asked if the gun that he brandished at a crime scene was loaded. Cogburn, played by John Wayne, played very well by John Wayne, dryly responds, that's my editorial comment, quote, a gun that's unloaded and cocked ain't good for nothing, unquote. Something similar might be said of a Supreme Court docket, particularly when there is a Second Amendment case that could prove one of the most impactful decisions of the term. The court will soon take up New York State Rifle and Pistol Association Incorporated versus Broom. soon. That's the organization I just mentioned a moment ago. More than a decade after its last major gun rights decision, the Supreme Court decision. The case promises to be a showdown between the Supreme Court and lower courts, which have been chipping away at the High Court's prior Second Amendment rulings. So I'll jump in here because this is something that has frustrated me, especially specifically in New York, because the Supreme Court was very clear that the Second Amendment is an individual right. You have a right to keep and bear arms. And the lower courts, as this article says, have been chipping away with it. They've been just, well, the problem is, well, let's just get into the article and you'll get some more details here. But the basic problem is that the lower courts have been finding ways of just making decisions that would prevent the Supreme Court decision from being implemented. And New York City specifically did pull the dirty trick too that you're going to see in a second here, and I'll give you some more details on it. In 2008, the Supreme Court handed down a landmark ruling in District of Columbia versus Heller, recognizing the Second Amendment as encompassing an individual right to bear arms. 2 years after Heller, in McDonald versus City of Chicago, the court ruled that this right applied against the states. Now, those are the two cases that were decided, and these are the cases, the decisions, the Supreme Court decisions that the lower courts, especially in my case, or especially concerning to me, the Second Circuit in New York. And by the way, things have been happening, thanks to Donald Trump, by the way, because he flipped the Second Circuit. Finally, the Second Circuit has a conservative majority. Until Trump came along, it was a liberal majority, which is why you always had these very restrictive gun case rulings. Anyways, back to the article. The new case concerns concealed carry restrictions under New York Penal Law, Section 400.002F, that require a showing of, quote, proper cause, unquote. This is the problem. Lower courts have upheld, again, the lower courts have upheld the New York law, but there are ample constitutional concerns over its vague standards, such as showing that you are, quote, of good moral character, unquote. The case presents a single, short, direct question: whether New York's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. And that's the problem in a nutshell. If you are in New York, the law today, as I said, it's almost impossible to get a gun because there's no, other states have a shell, what they call a shell issue. And in fact, where I am in Tennessee, I can carry a gun now. When I came to New York, or when I came to Tennessee, one of the first things I did was to apply for a concealed carry license, and it was very simple. I'd go take a one-day course, and then I just went to the DMV where you get your driver's license and applied for a license, and I got it in a few days, and that was it. It was that simple. And well, I had to, as part of the course, one-day course, and I had to go to a shooting range and I had to shoot at a target and show that I could handle the gun. I scored 100%, by the way, on my marksmanship. On the other hand, the target was only about 7 feet away, I think it was. It wasn't that far away. Anyways, maybe a little more, 7 feet or 7 yards. I don't remember. Anyways, I got 100%, and I even have the target hanging on my wall somewhere. I was so proud of myself. But getting back to this point here, that other states have, oh, and I was going to say now in Tennessee, it's now what they call a constitutional carry state. They passed a law where you don't even need a permit anymore. You can just go into a gun store, buy a gun. You have to fill out the federal paperwork, which takes a minute to get the background check. But then to carry the gun on your person, you don't. you don't need a permit anymore. You can just do it, which is very good. But you contrast that with New York, where you have to show why, you have to give a reason. You have to fill out a 50-page form, I understand, demonstrate or arguing why you should be allowed to carry a gun because you're being threatened or something, or, well, as it says in this article, you're a good moral character. You have to. The point is that some functionary at the police department decides whether you can have a gun or not. They just decide and say, okay, well, you're qualified to have one, and oh no, this person is not, this person is. And isn't it funny that, well, Donald Trump himself has a concealed carry permit. Howard Stern, the radio personality, he has one. The point is, if you're wealthy or a politician or connected, you can get a concealed carry permit. It's the average person, and some of these people with bodyguards, they have bodyguards and they have concealed carry permits. Meanwhile, the average person walking through Central Park in the middle of the night, he can't get one. Or my neighborhood, somebody was shot right across the street from me. If you're a criminal, you can get a gun. If you're willing to get a gun illegally, you can do it in New York. It's not hard. It's the law-abiding citizen who finds it almost impossible to get a gun in New York City. And it looks like finally this matter is going to the Supreme Court. Now, what's important here is, well, let me just give you a little more detail. Well, from the article, I'll read you a little more. The selection of a New York case is particularly poignant. Some of the justices were none too pleased with the Big Apple last year when city officials suddenly sought to withdraw a case on the court's docket. New York politicians had passed a law that many of us, that would be Jonathan Turley, the author of this article, prominent law professor, you probably have seen him on TV. Anyways, he and other people, other legal authorities, have, well, many of them viewed this law, this New York law, as unconstitutional with its imposition of burdensome limits on the transportation of lawful guns from homes. Those politicians publicly thumped their chests about going to the Supreme Court with the law and limiting the Second Amendment precedent. Professing absolute confidence, they litigated the law, and again, the Second Circuit supported the dubious statute. The Second Circuit, again, whom I just mentioned, this Second Circuit that always rules in favor of New York City and against gun owners. But this time, this is what's different. The Supreme Court accepted the case for review and was expected to overturn the law until New York suddenly changed the law and then quietly sought to withdraw its case before any ruling. So what happened was the Supreme Court was going to, they wanted to take the case, they wanted to use that case to reinforce their previous, the two decisions I mentioned earlier. Well, what I want to get into is, let me just describe the law first. This was the law that New York had. If you had the pistol permit, not to carry it, as I said, that's almost impossible, but you could get a permit to own a pistol, but you had to keep it in your house. You could not take it outside of your house except under, two conditions, which were to take the gun to, there are two pistol ranges in New York City where you can practice, right? You can practice your mark, where you can go shoot your gun. You could only take your gun out of your home to one of those two pistol ranges, and you had to have the gun and the magazine, the ammo, locked up separately. They had to be separate, so the gun had to be unloaded, had to be in a locked container, and you could only take it to those two places outside. Other than that, you had to keep it in your home, in New York City. You would be talking about an apartment or your townhouse. So you had to keep the gun in your home. You could not take it out of your home except to go to these two pistol ranges. So obviously that's very, very restrictive, and the Supreme Court would have struck it down. But before the Supreme Court could actually hear the case, New York City repealed the law, and they did that specifically to prevent the Supreme Court from hearing it. In other words, to make it, as they say in legal terms, moot. To make it that it would make no more sense. It would not make sense anymore to litigate the case because that law was no longer on the books. New York City repealed that law specifically to keep the Supreme Court from hearing it, because if they had heard it, the expectation was that the Supreme Court would strike down that law and it would create a precedent. And then that precedent, that was the problem. New York City, if that law did get struck down, it would create a precedent for other cities. Other cities have that same law, very few, but if there are other cities that had that law, then all those laws would be struck down. So New York City repealed its own law. I guess somebody in some other city could bring the case somewhere else, or a similar case. But anyway, the point is that, well, I'll read from the article because, well, here, the court ultimately dismissed the case, but did so over the objections of 3 dissenting justices. There was a rare instance in which the court resisted such a mootness ruling after a party sought to withdraw. But then few litigants have had the temerity to do what New York did. Justices Samuel Alito, Neil Gorsuch, and Clarence Thomas specifically called out New York for, quote, manipulating, unquote, the docket by withdrawing an unconstitutional law just before a final opinion, which is another important point. In other words, the law was unconstitutional, and had this case not been brought and had it not been on the Supreme Court docket, that law would still be enforced, this unconstitutional law. So that law should never have been passed in the first place, but also New York City should have just repealed the law anyhow. But this is the problem that the gun owners have been having, that these lower courts ignore what the Supreme Court said, and then you have to go to the court system for every little variation of every individual law or statute to get it overturned, and only then, if it's going to the Supreme Court, will a city maybe repeal the law. But this one is the big kahuna in New York City, the law that says you don't have a constitutional right to carry a gun. You have to demonstrate a need for the gun. In other words, the burden is on the person who wants to carry the gun, not on the government to show, the local government to demonstrate that you should not be allowed to have a gun. So it creates a situation. My point is that this law is so important to New York City that they are not going to repeal that law to keep the Supreme Court from hearing the case. This is so important to New York City that they are not going to repeal this law. So it will go to the Supreme Court. They are going to hear it. I understand that the argument it'll be argued on December 1st, I think. Don't hold me to that, but I think it will be. So we'll have a sense December 1st, just maybe a month and a half from now, that because when you hear the argument, you can sometimes just hearing the argument, how the Supreme Court justices respond, get an idea how they're going to rule. But also, getting near the end here, this has probably been one of my lengthier vlogs. I just mentioned 3 Supreme Court justices who wanted to hear the case, and they had to moot the case and just not hear it because of what New York did on that previous law. But going forward now, Justice Brett Kavanaugh joined in the condemnation of the 3 justices that I just mentioned. I don't think Kavanaugh was on the court at that time. That could be why he wasn't with the original three. Anyways, Justice Brett Kavanaugh joined in the condemnation and added menacingly that, quote, some federal and state courts may not be properly applying Heller and McDonald. The court should address that issue soon, perhaps in one of the several Second Amendment cases with petitions for certiorari now pending, or certiorari, now pending before the court. Certiorari means hearing the case. That's just it means a petition for the court to hear the case. Well, unquote. The court then did precisely that by accepting a case with the very same plaintiffs, New York State Rifle and Pistol Association. On this occasion, however, the court is unlikely to tolerate another bait and switch by state officials trying to withdraw the case at the last minute. If those four, this is the important part, if those four justices are still intent on pushing back on lower courts, they need only Chief Justice John Roberts or Barrett, Amy Coney Barrett, the newest justice, to hand down a major ruling in favor of gun rights. Amy Coney Barrett, when she was a lower court judge, she issued an opinion very strong, supportive of the Second Amendment opinion. I don't remember the exact case. The point is that you're going, and I believe Roberts was in on either Heller or McDonald, maybe both, I don't remember. The point is that this court, I just said why I don't think that New York City would change the law to change their law to make the case moot. If they did, great. That would be fantastic. Well, I think it's going to be true in any case that it's going to be easier to carry for law-abiding citizens to carry a gun in New York. But it looks like it only takes 4 justices to agree to hear a case. Not to rule on a case, but just to hear it, you only need 4 justices. So the 4 justices are still there, and it looks like they're not going to let New York City, even if they want to change their law or do anything to withdraw the case, they are going to hear the case. And to me, that is why I often give you my disclaimer. I'm a conservative. Always keep that in mind when you consider whatever I have to say. But as a former New Yorker, I lived there for well, I'm actually a Michigander. I grew up in Michigan, born there. I consider myself a Michigander. But adopted New Yorker, lived there for 40 years. And that was one of the frustrating things about New York, because there are, even under Giuliani, which is when New York was at its safest, and to give him credit, Bloomberg, that there were still problem areas, and you want to be able to carry a gun. There were somebody was shot right on 57th Street around 8th Avenue, 7th Avenue, by Carnegie Hall. That would be 7th Avenue. A lot of people, broad daylight, and somebody just walked up to somebody, put a gun to the back of somebody's head and just pulled the trigger and shot him and ran away. Things like that happen in New York, and it's unconscionable that law-abiding citizens cannot defend themselves. So I hope they will soon. And definitely, if I ever get wealthy and have my PETA tear, which you can help me to do, by the way, by subscribing to my video, but I definitely would get a concealed carry license if I'm ever back in New York, and I would carry it with me everywhere. Darn right. And that's it for today. Thanks as always for stopping by. If you have any comments, especially if you're in New York, if you have any comments, comment section below the video. You can also put questions there, suggestions for future topics. You could subscribe. I love getting new subscribers. You could share the video with anybody you think would like it too. And come back and see me again. I would love to see all of you again. I definitely will keep everybody informed of the progress of this very important, to me anyways, case. It should be important to everybody who's living in New York right now. But I'll keep you informed hopefully of how the argument goes in the Supreme Court, my impressions, but definitely the final decision, which I would expect to come well, no later than the fall of next year, 2022, but probably in the summer. I think that's when they issue their decisions. And that's it. Thanks a lot. Well, as I said, I'll look, well, just bye.